For admission, item number 1.
I plead your lordship. Lordship, the engaged counsel, my senior estimate, he is not well. He is suffering from fever. Lordship, similar interest matter is pending before principal bench, writ appeal number 320 of 23, and it is fixed on 12th November.
12th September.
November.
You are appearing for
Respondent, my lord.
private respondents.
Private respondents. Four to 11.
We can adjourn the matter since the lawyer is ill. Both sides are represented. On behalf of Mr. S.K. Mehdi, learned CGC, the prayer for adjournment is made on the ground that he is unwell. So matter stands adjourned today. List after?
After
Next.
12th November, my lord. Since similar matter is to be...
No. Because if it, some orders may be passed because otherwise you will not get opportunity to contest or to bring your affidavit on record.
May I pray for a date? Can it be on 26th, 8, 2026?
Next division bench, when it is there?
26 is Saturday.
No, when is our next division bench?
It's a holiday.
12th, 2nd of September. 2nd of September.
Supplementary list item number 12.
May I please, Your Honor?
Yes.
This appeal against the impugned judgment and order. Lordship, actually it was listed in the supplementary list. So I thought it will come in the supplementary, so I'm a little bit in.
Yes, what do you have to say?
Yes, Lordship, this is an appeal against the impugned judgment and order passed on dated 29/7/2026, arising out of the succession certificate case 1043 of 2025. Lordship, in this case, the appellant is the surviving great son of that is Inderjit Singh Bagal. In spite of that, succession certificate was granted to the housemate, that is Pramila Baskit.
Please show us the previous order of succession case number 1244 of 2018. What is that?
That is awarded to the Charanjit Singh Bagal Lordship, which is already again cancelled by the Honorable High Court Lordship.
Where is that?
Page 157, Lordship, is 158. 157, 158, Lordship, that is.
157.
Yes. Lecture 5, Lordship, that is. Annexure 4, Lordship, that is. Your Lordship, it is mentioned that as the parties belongs to the Sikh religions, they are governed by the Hindu Succession Act. So even in this case, Lordship, in spite of much opposing that this case, Indian Succession Act is not applied because they belongs to the Hindu Lordship. So this should be as per the Hindu Succession Act of 1956, Lordship. But in this case, Lordship, order was passed as per Indian Succession Act, which is in violations of the provisions of law, Lordship.
What is the document on which basis of which the succession is
Succession is
Claimed.
based on authority letter, Lordship. It is alleged authority letter was made by
which page?
Charanjit Singh Bagal, Lordship, before
Which page?
one five five, Lordship, page 155.
One.
Page 155, Lordship. It is, Lordship, it is written in Hindi, in translate copy is there, Lordship. Ah. Ah. And 156 is the original, Lordship. So no name is written, only signature, Lordship.
Heard counsel for the appellant. Next one, by filing this appeal under section 384 of the Succession Act, 1925, read with section 17 of the Mizoram Civil Courts Act, 2005, the appellant was the respondent number, substituted respondent number 1 in succession certificate case number 1403 of 2015. As I said, the judgment and order dated 29/6/2026 passed by the learned additional district judge Roman 2, Isol, in the said case, thereby granting succession certificate of the debt and securities left by late
Charanjit Singh Bhogel.
Charanjit Singh Bhogel, BHOGL. Next one. In view of the projection made in this, in the memo appeal, the appeal is admitted for hearing by issuing notice, issuing rule returnable forthwith without requiring any steps to be taken. Sorry, we should do returnable on so and so. The appellant shall take steps within 2 days for service of notice, 2 working days for service of notice on the respondents by speed post with AD. Next, by the learned counsel for the appellant is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. List on so and so.
Lordship, you have
Reason
a
IA.
interdict.
As the appeal has been admitted for hearing, the court is inclined to stay the operation of the succession certificate dated so and so, passed by so and so, in case no so and so. Next paragraph. Issue notice returnable on so and so. The applicant shall take steps within 2 working days for service of notice on the respondents by speed post with ED. Next paragraph. List on so and so.
Lordship, if the operation of the impeached order is not the very purpose of the RFA,
We've already
it is
stated.
defeated, Lordship. It will be defeated.
We already
because-
stated, you did not hear, we already stated.
Thank you, Lordship. Obliged.
Daily list for motion item number 1.
Yes.
Your Lordship, my Lord, this is a criminal petition. My lord, this honorable court, the coordinate bench of this court had allowed for release of the seized currency.
We posed a query on the last date, 11/8.
Yes, my lord. My lord, if I may withdraw and file an interlocutory application in the disposed criminal pet. Would
You
that
can
be
do so
more
because we'll have
appropriate?
to take that call. We can't say what is to be done. It is for you to take a call.
If I may be allowed to withdraw this application so that I can file
That would be-
IA
That would be
with the
okay.
liberty. Yes, ma'am.
Heard Ms. Swansod and counsel for the petitioner and Swansod honored ABP for the state. Respondent number.
Sole respondent.
Sole respondent
Yes, sir.
of the state.
Respondent number 1. Next para. This court by order dated 11/8/2026 had observed as follows. Observed as follows. Para 3 and 4 on the last order. Next para. Accordingly, the learned counsel for the petitioner, upon instructions, crave leave of this court to withdraw this application and to this petition and to approach this court in an appropriate jurisdiction. First of prayer is allowed. The matter stands disposed of on withdrawal with liberty as prayed for. Next para. It is clarified that the merit of the matter has not been gone into.
Oblige.
Item number 2.
May I plead your lordship? Lordship, kindly adjourn the matter for the day.
Same ground.
Same grounds, sir.
My lord, I have one small submission. I have one small submission.
Yes.
In the present case, they are challenging the assessment made by the DC after a period of 7 years, and no explanation whatsoever has been made in the.
Whatsoever, but the counsel is ill.
Understood, my lord. But then in the meantime, they can take that time to at least file an additional affidavit to
You
explain
do
the
so, there
delay.
is no bar.
No, my
have
lord,
to-
what I'm trying to impress upon your lordship is that in a similarly situated case, this court has already passed an order saying that directing them to file an affidavit explaining the delay.
No, you file it. Have you stopped any?
No, not me, my lord, not me. The petitioners, they have to explain the delay. There's a 7 years delay.
That they will make a submission. Why should I ask them to supplement it? It's not the prayer of the petitioner to allow him to supplement. We are not passing any orders which create any right on anyone.
Because similar order was passed, that's why.
I have my reservations. Why should I permit you? Supposing you are the petitioner.
Not me, my lord.
Please understand. If you are the petitioner, why shall I of my own ask you to supplement your petition and to improve it?
No problem. In fact, that benefits me, so.
In the bench, I am the last one to do it.
It's for my
Unless there is a
benefit,
prayer made, it is for the petitioner to take a call how they want to present the petition.
sir. Very well.
We don't have the advisory role. I have my own reservations.
Understood.
I am not speaking over this, but for myself, I have reservation.
Understood.
Both sides are represented. On behalf of the learned CGC, Mr. S.K. Medhi, learned CGC, prayer for adjournment is made on the ground that he is ill. First of matter stands adjourned today. List again on.
Next week,
Date may be given.
Give a date next week.
lordship, interim prayer may be extended.
What is the interim order? Okay, interim order passed earlier stands extended till the next date of listing. Full stop. However, comma, it is made clear that the further extension of the interim order would be subject to further orders that may be passed on the said date. List on so and so. This interim order, without a notice being issued, is was not correct. But since the bench has already passed on, now we are extending it. But next date, the extension will not be automatic.
21st August.
21st.
Lordship, can it be on 24th August?
No, we asked you, you said you would give a date. If you wanted a date, you said tell us.
Lordship,
24th, make it. We asked you when.
Item number 3.
Similar order can be
Lordship,
passed.
similar.
In
Item 3 to 7.
3 to 7. Same
My
order.
lord, 6, I have some reservation. I have one small submission because this is slightly on a different footing.
Okay. Give
Item
6. Apart from 6, others till 7, same order.
Because this is purely on law.
Yes.
Out here, Your Lordship, what they're challenging is the order passed by the DC, wherein I was given the benefit of interest under Section 28. The order was passed by the DC on 12/9/2022, which is at page 13.
Against this appeal would lie.
In my humble opinion, appeal should have been preferred, but they've come by way of writ petition. In any event, Your Lordship, just looking at the law point, purely on the law point, out here at page 5, para 7, this is their only submission. Page 5, para 7. May I read, Your Lordship? That the petitioners state that the petitioners here are not liable to pay statutory interest under Section 28 of the alia Act 1894 from the date of possession. They're saying that they're not liable from the date of possession.
If it's an order in a land acquisition case, where is the order?
The order is at page 13.
30.
Sorry, no. Page 10. Page 10.
10.
Annexure A. This is the order of the DC whereby I was given the benefit of Section 28, interest. Relevant paragraph is at page 12. Apologies.
Okay, so they are challenging the assessment.
Correct. So, and the next page, Your Lordship, this is the assessment. This is the order for assessment. Next page is the assessment. And the horizontal page, page 14, column number 11.
Yes.
Your Lordship can see that it's calculated from the date of possession. So they are saying that it should not be from the date of possession. That is at para 7 of their writ petition. That is their only submission. If we kindly look at Section 28 of the LA Act of 1894. Section 28, LA Act 1894. Your Lordship has it? May I read, Your Lordship?
Just a moment. Section
28. 28.
Yes.
Yes. If the sum which in the opinion of the court the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation, the award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land. It is there in the statute itself. How can they challenge it? It's a given. That is their only, para 7 is
You are
their
right.
submission.
Yeah, you are right. Heard Miss So-and-so, give your name. Learned counsel for the learned counsel appearing on behalf of Mr. S.K. Mehdi, learned CGC. who prays for an adjournment as the learned CGC is indisposed. Next para. Mr.
Lalpa
Please give the names. I make a
Asha.
mistake in
Asha.
spelling. Learned counsel for the
Private respondents.
private respondent,
3 to 11.
number
3 to 11.
3 to 11, has raised a preliminary issue of maintainability of the writ petition on the ground that the appellant has assailed the order dated
Page 10
8/9/2022
and page 13.
and communication dated 12/9/2022. This, the first one, order dated so and so, make it within bracket annexure A, and the second one, 12/9/2022, will be annexure B, by which interest on
Excess amount of costs.
excess amount of compensation was ordered to be paid on and from the date of taking over possession. Full stop. The preliminary objection as to maintainability was made on the ground that as per the prescription of section 28 of the Land Acquisition Act, 1894, payment of interest is to be levied from the date of possession. Next paragraph. The court finds force in the submission of the learned counsel for the private respondents. Next paragraph. Accordingly, on the next date of listing, the matter would be heard on the issue of maintainability. Next paragraph. List on. Give the same date.
Same date, madam. Deeply obliged.
Much
In item number 4 and 5, I may be given a liberty to file my counter affidavit.
File it. We have not even issued notice here. You can file it. Because you have not issued notice. You have not issued a notice. You can file it.
My lord.
Item number 8.
Lordship, I'm appearing on behalf of my senior for the respondent number 6, my lord. And we'll be filing our power within next week, my lord.
Within this week.
Within next week, my lord.
Okay, all sides are duly represented.
If I may interject, Your Lordship, in the meantime, if I may be allowed to file my rejoinder affidavit, because affidavit in opposition has already been filed by respondent 1 to 5.
All sides are represented. The learned counsel for the petitioner prays for and is granted 2 weeks' time to file affidavit in reply in respect of affidavit in opposition filed by respondent numbers
1 to 5.
1 to 5. Next para. The learned counsel for the respondent number 6 has entered appearance. You filed your wakalatnama?
Yes, my lord. My senior is the standing counsel, my lord, for respondent number 6.
No, I'm asking, wakalatnama has been filed?
It's not yet filed, my lord.
Okay. Then give your name.
Yes, my lord.
Just record her name. So learned counsel enters the appearance for respondent number 6 and prays for some time to file wakalatnama and the affidavit in opposition. Next prayer is allowed. Next paragraph. The affidavit shall be filed at least 2 days prior to the next date of listing. Next paragraph, list on. Give a date after 2 weeks.
31st August.
Obliged, Your Lordship.
Item
number 9.
Split it to another paragraph. The affidavit by both sides shall be filed. 2 days prior to the next date of listing.
Lordship, my senior is only, so may this matter be passed over for a time being.
Time being.
I apologize. I was on lapsing code number 2. Not really. My lord, we have just received the paper book by the parties.
Just a moment.
Yes, my lord.
Okay, yes.
We have just received the paper book, and the appeal was already admitted, and this is second appeal. This court has already formulated the substantial question of law, and the matter may be fixed for final hearing on some other day.
Pardon me?
The matter may be fixed for hearing on any other day.
Ah, yes, you can proceed.
My lord, I'm not ready for hearing today in the main appeal.
You don't want to do it today.
It may be fixed on some other day. So far as the IA is concerned, my learned friend is had insisted on early disposal of the IA on the last occasion. The IA pertains to staying the operation of the impugned judgment order, and he had already filed his objection. So far as the main case is concerned, my lord, the dispute between the two rival parties.
Where is, on what substantial question of law the matter has been admitted? Decision of court below accepting the cause of action as temper is valid now. So it was barred by limitation. The entire property was made in 1980. And also considered a claim. What is the relation between the plaintiff and the defendant?
The suit property was initially purchased by the instant appellant, and the claim of the instant respondent was that she had contributed some amount of money for purchasing the land, and she is entitled half portion of the land. The suit land was purchased by the instant appellant, and it has been mutated in the name of the appellant alone since the year 1984.
So suit was decreed.
suit was dismissed.
Dismissed.
Degreed in favor of the respondent.
And the first appeal was dismissed.
It has to be the suit property has to be distributed between the parties.
The suit was decreed.
The suit was decreed in favor of me consecutively. Civil suit and RFA, it was passed
The
in
suit
favor
was
of me.
degreed, my lord.
Suit was decreed.
Yes, my lord.
Then you filed the first appeal.
Yes, your lordship.
Appeal was dismissed.
Yes, your lordship.
This is the second appeal
This is second appeal.
on the ground of limitation.
The first one is on
2016.
the ground of limitation, and the second one is that the purported documents which the learned trial court had held it as inadmissible was reappreciated by the first appellate court in the absence of post objection from the respondent. And the main dispute is that the claim of the plaintiff respondent was that the suit property should be distributed apportioned into two persons. And in my IA, my lord, applying for stay, I was only under the impression that the suit property has been renumbered, redemarcated by the revenue authority. So I was only seeking to maintain status quo pendency of this present appeal. And the respondent had now clarified that no steps have been taken in pursuant to the direction given by the lower court. I was afraid that the revenue department might have taken steps to bifurcate the suit property during pendency of this appeal. But my learned friend in his objection had clarified that no steps have been taken by the revenue authority. When the suit property, the land pass was renumbered, I was under the impression that it has been acted upon in terms of the impugned judgment.
We are not granting you injunction, but the status quo which was granted,
Yes, my lord.
that would continue.
Yes, my lord.
Both sides,
Yes, my lord.
the,
Fair enough. Fair enough.
the status quo would be by both sides.
Yes, my lord.
Your lordship, on the part of me, if the status quo is maintained, it will cause balance of inconvenience in favor of it because the applicant already enjoyed her portion of land because we are siblings. We are my elder sister and I'm the younger sister. We jointly purchased the land, and she already enjoyed her portion of land. And if I'm continuing restraining my portion of land, it will cause severe injustice and balance
No,
of
status quo of the land protects both sides.
Your
They will not encroach any other portion of land. And so far as you are concerned, you were not in possession ever.
Your Lordship, in pursuance of the impugned judgment and order, civil suit, as well as the RFA, a detailment order for bifurcation of the joint purchase land was already issued.
You see, once there is an appeal on which has been admitted for hearing, can we allow the status of the land to be changed?
Your Lordship, because according to my understanding, he have no merit and the prima facie to proceed the case further and no chance of
You
succeeding.
forget about
appeal.
that. Order 41 Rule 5 permits us to stay the operation of the decree.
My Lord, yeah.
Then, what do you want to do? Please tell us very clearly, what do you want to do if there is no status quo?
Your Lordship, the detailment order by
You see, I have asked you first question, are you in possession? You don't give that answer.
Okay.
You are in possession or not in possession of any part of the land? So you are not. Silence speaks. So if you are not in possession, can you take law in your own hands and take over possession? Can we permit that? Equally, if the land is half purchased by the appellant and half by you, they also cannot encroach and make any construction on the other part of the land.
My Lord.
Then, But he's technically very correct. You see, you have filed this application not only under Order 41, but you have invoked Order 39, Rule 1 and 2. If you invoke Order 39, Rule 1 and 2, your suit is decreed and his suit is decreed and the appeal is dismissed. There is no prima facie case. He's otherwise technically very correct.
At this stage, my lord, my learned friend had already clarified the point that no further steps have been taken by the revenue department.
That is different. What the revenue authorities do is not our concern in the appeal. Our decisions are not dependent on the revenue authorities. The fact is that once you file an application and you use Order 39, the three golden principles must accrue in your favor, which is not.
In the present case, I have been having this
No.
constructive
And you see,
managerial position
the mere fact that you wanted an adjournment today is indicative of the fact that you are trying to escape.
No, my lord. We have just received this paper book, and on the last occasion,
Because-
my learned friend is only insisting for disposal of the IA.
Yes. You can even dispose of this appeal would not take us more than the required time.
I just need some time to receive my final material instruction from my client.
There's nothing, you see, when you file an appeal, you have instructions. The substantial question of law is only one. Will the client tell you about the law? I'm sorry, that can't be accepted. We address you as learned counsel. We don't address the clients as a learned client.
If the IA may be taken up today,
I will pass an order. We gave you both the options. If you are insisting on the IA to be taken up on merit, then you don't have a case because you have added Order 39, Rule 1 and 2.
I'm not pressing on that portion, my lord.
But you can't escape. This is something which is inherent. The Order 39 2 is an integral part of your application. You can't segregate it. Can we do it? Can we read one part of the petition and do not read the other part? Will you be happy? You just have to file an affidavit that in your cases we can read half of the petition, do not read half of the petition, and you will not be aggrieved.
At this stage, my lord, if status quo is continued as it is,
That we have said we are doing
no
it.
prejudice will be caused to both of the parties.
No, prejudice is being caused to him. The reason is that he is half sharer of the land. You are joint purchasers. Can you deprive him of the fruit of his purchase?
That is yet to be,
Does the principle of adverse possession operate against the real owner when you are brothers and sisters?
that is yet to be considered in the appeal. Whether she had actually contributed her in
There is
purchasing
no,
the
in fact, in your appeal, it would be better if you hear the appeal. By this time, this appeal hearing would have been over. We don't have more than 5 questions to you. It's a pure question of law. And don't say that your clients will give you instructions on that. Adverse position would come only when you create an adverse title. How did you assert your adverse title against the respondent? There's nothing on record. Your plaintiff says nothing.
They are the plaintiff, my lord.
In your defendant, sorry, you're in your written statement. You don't create adverse position.
My lord, my title, it has been mutated in my name since 1984, the suit property. And it was all alone in my name. And I'm having the constructive
Which is the law which says that mutation overrides the title deed?
They never raised any dispute regarding the mutation, my lord. And in the year 2009 also, when I began
You
construction.
cannot distinguish the title just like that.
And
Merely because you have some connection with the revenue officers, you
No, my
managed to
lord.
have your name.
She do not have any valid instrument to assert her right over the suit property.
You yourself say that he is the joint purchaser.
Joint purchase line.
That is the contents of.
Where is your sale deed? Which page is your sale deed? Your purchase deed is where? You have the DCR here? DCR? I think there is no sale deed, but there is only a willingness certificate.
That alleged willingness certificate was held inadmissible by the London trial court. The claim of the plaintiff based on the alleged willingness certificate,
Then we,
Your Lordship, the
there
suit,
is nothing
the
more.
suit
You
was
just want
quit-
an adjournment, we adjourn it, then the matter can be decided.
the matter may be adjourned for today, my lord.
Okay.
I won't wait, Your Lordship, this is time.
What says the representative? The Learned Counsel for the appellant prays for another date for hearing. This is item number?
But, well,
Nine.
I'm sorry, 9. Which item number? Item number 9. RSA
Your Lordship,
number
can
3.
it be on the fixed date?
As the paper book is ready, the matter is ready for hearing, so accordingly, list the matter for hearing on, give a date when. Just give the date later on.
Any date after 3 weeks. Any date after 3 weeks, as per the convenience of my land.
After 3 weeks will be, Your Lordship, after 1 week, if it is possible, or first week of September.
I have already few cases piled up in the next 4
you can both go outside, have an arm wrestling competition and then come back.
I already have some other few fixed items in the coming next 2 weeks.
Your Lordship, my humble suggestion is 2nd of September.
Second is a division bench, make it
Oh,
third.
third, yes.
Make it 3rd of September, okay. 3/9/2026.
You'll be obliged.
And
My
this,
lord-
in this IA, both sides are represented. By an order dated 29/6/2026, the court had granted status quo in respect of the suit property, which is the subject matter of the connected appeal. Full stop. Next, accordingly, the both sides, i.e. the applicant and the respondent, are directed to maintain the status quo in respect of the disputed land till the next date of listing. Next para list on same date. Third.
Much obliged.
You'll be obliged.
Item number 10.
Lordship, this is bail application which come up for the first time. So formal notice may be issued and
It's come for the first time. Okay. Who is appearing for the narcotics? You are there? Okay. Both sides are represented. You should notice in this, in respect of this bail application, which is filed under section 483 of the BNSS, read with section 37 of the NDPS Act, 1985 for no, the 585 full stop. Next para. Objection, if any, by the state shall be filed on the next date. Next by the respondent is permitted to file to produce instructions as regards the previous criminal antecedents, if any, of the petitioner. So accordingly, the learned. You are called the special counsel or APP?
APP.
Learned APP shall
My lord,
communicate the order of the court to the excise and narcotics station, to the officer in charge of excise and narcotics station. Next para. List on 10 days. After 10 days?
Yes.
Give a date after 10 days. Yes, you were saying something?
my lord, the charge sheet is not yet submitted in this case, and case diary may be called for, if possible.
What?
Case diary may be called for, as charge sheet is not yet submitted in this case.
Okay. Issue notice. We have said issue notice. Let the case diary be called for. Scanned copy of the case diary be called for, without requiring the original case diary to be produced. It's not the original one. And criminal antecedents. For that, you communicate the order.
27.8.
Obliged.
Supplementary list, item number 11.
There is a typing error in this order. Huh? Say both sides are represented. The matter has been listed owing to a typographical error. What was the typing error?
Lordship, para 4.
This undisturbed should be what?
Third.
Huh?
Typing errors.
This is last order. Oh, अच्छा, अच्छा. हाँ. Missing an order as in paragraph 4 of the order by which substantial question of law was framed. Next para, in the substantial question of law, in fourth line, the word inverted commas, neutrally, N-E-U-T-R-A-L-L-Y, destructive, inverted comma closed, is mentioned, which ought to have been mutually destructive. M-U-T-U-A-L-L-Y, mutually destructive, inverted comma closed. Accordingly, next para, accordingly, the substantial question of law, comma, upon correction of the typographical error, comma, would now read as follows. Please retype it again. This para 4. Only that fourth line neutrally should be mutually. Next para. This order shall be read together with the order dated 11/8/2026. Okay.
Obliged.
Then you just say the last line. As directed earlier, comma, list the matter on 11/9/2026.
Part 2 hearing list, item number 22.
I don't think anybody is ready for part 2. Just ask if somebody is there. Is anybody there ready for part 2 item? Any item part 2 is ready for hearing? Are both sides available for the any part 2 matters? If they come, we'll take it up at second half. Or anytime they come, we'll take it up. If both sides are present. Just call me, I'll come. If both sides are ready, I'll come and take it up. Any part 2 matter.
Hearing list item number 22.
Yes.
First of all, I apologize.
It's okay.
for the- Yesterday, the respondent number one, they tried to, they were seeking your indulgence for adjournment because the main counsel of the respondent number one, she's hospitalized, you see, because she got pregnant. That's why she's suffering
Okay.
from
You,
something.
you are for?
I'm the-
Respondent number 2, my lord.
Okay.
This is mainly between the appellant and the respondent number 1. Since
Okay.
the counsel for the respondent number 1 is having such personal difficulties, this matter may be adjourned and taken up after 1 week, my lord.
Okay. The appellant and the respondent number 2 are represented. Next para, the learned counsel for the appellant has submitted upon instructions that the learned counsel for respondent number 1 is not available.
Yes,
Accordingly, matter stands adjourned today. Next para, list on.
25.
Okay.
Much, my lord.